Good morning, good morning, good morning. Well, depending on where you are, good evening, good afternoon, replay crew, good day, whatever day it is where you are. Today is Wednesday, November 12th. We have quite a lot to talk about. And as you know, I'm getting ready to travel, fingers crossed, to BravoCon. So I'll be keeping you in the loop on those adventures too. If you have the Lawnerd app, I'll be keeping you in the loop there. And on social, if you're like, girl, just tell me the tea and a members only live when we get back. Don't worry, I'll do that too. But if that is coverage that you want in the app, in our member spaces at the Lawnerd Lounge, and on social media at the Emily D. Baker on Instagram, it's really the only platform other than the Lawnerd app that I use on the regular. It's good to see you guys. Let me know where you're coming in from and what you're drinking. We have much to talk about today. I have a new mug. I know. I have a new mug. Look, I couldn't. I'm having a green moment. I'm just embracing it. I'm just embracing it. So new mug. I know. Got a cappuccino. It's still cold here. Look, it's got a little like mermaidy tail. Look, don't waste your time on the bear mug. This green mug, like it could be Christmas vibes. It could be mermaid vibes. It doesn't matter. This one, forget about the glass bear. This is the one, and you'll probably find it because it's amazing. But it can feel like evergreen Christmassy vibes, but it could also just be you love green. And those of you who are like Wicked for Good, yeah, pick your green. Pick your green. Or Green Machine Cavaliers. Either way, pick your green. But we are getting ready for BravoCon, which is why we're early today, because I have things I have to do today, and I have to overcome my, packing procrastination, because I cannot start out BravoCon with no sleep before travel day, because then I will be totally screwed and I will struggle. So I have to pack. I never know what to wear. Everyone who I run into at events like this is like, oh my God, it's so good to see you. You look amazing. I'm like, I have anxiety. Once I'm here, I'm fine. But the getting from my house to here, not fine. But not as much anxiety as I have over this case right now. Yesterday, I was thinking about a couple different things that we might talk about and catch up on today. The Kouri Richins interview of her defense attorneys is one of those things I have not covered yet. And then I started looking at the docket. And then I immediately texted Chris. And I was like, let me just bring you into this text exchange on my end last evening. Girl, something's going down in the Kouri Richins case. And a lot of it is sealed. And it looks like one of the defense attorneys has an attorney that has appeared on the record. And there are multiple sealed declarations from prosecutor Brad Bloodworth. Blood. No, I do not say blah, blah, blah. There are multiple sealed declarations from Brad Bloodworth. There's an OSC. It's all sealed. We're going to look at the docket together. We're going to look at the defense attorney's interview. We hadn't covered it, but the defense gave an interview. You know how Judge Beard Voice feels about the media. We are going to responsibly look at what is on the docket, and we are going to put a huge question mark on I have questions, and we are going to keep an eagle eye on what is going on this docket. Oh, and the court amended an order. So we're going to look at the court's amended order. Y'all, something's going down. Something's going down. Something is going down in this case. Why did the prosecution ask for an order to show cause? Why does one of the defense attorneys have an attorney that has appeared on the record? And why did they strike and seal all those appearance filings? We still could figure out what it was, though. Your girl was a research attorney. Remember, for those of you that are new, you're like, Emily, I can't remember. I didn't know it. Before back in my day, when I was a wee attorney waiting for bar results, I worked as a research attorney for 2 judges. If there is a thing I can do, digging up information is one of those things. Turns out you need more than that to pass the bar. It does. But digging up information is a critical skill of attorneying. Something is up, and we're going to talk about it. We're going to talk about it all. And I figured that we need to watch the interview because we haven't watched the defense attorney's interview. Why are they doing interviews? This defense team has bitched up one side and down the other, and for a full country mile with a Midwest goodbye. I don't know how else to elucidate how much they have complained about the media in this case. And then they sit down and give an interview? Sure, Jan. Sure. And then, after they give the interview, the prosecution starts filing a bunch of stuff. And if you don't know who Kouri Richins is, don't worry. We're gonna roll the intro and then I'll tell you all about it. We're gonna give you a full road so far. If you are new to the Kouri Richins case, go ahead and put a 1 in the chat. It will help me determine how fulsome the road so far needs to be as I roll the intro. So if you're new to this case, put a 1 in the chat. If you're not, well, you know what's coming. Oh, look at all those that are new to this case. Oh, law nerds. Buckle up. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. I see some of you also saying, like, I think I know this case, but also I forget things. It's totally fair. The Utah versus Kouri Richins case, obviously coming out of Utah. She was arrested May 8th, 2023. No, 2024, after the suspicious death of her husband in March 2023. It took a year for her to be arrested for the murder of her husband. She had written a children's book. You might remember this part. She had written a children's book about grief called like, Are You With Me? Or Dad, Are You With Me? Or something about walking through grief with her and her children. And then not only was she writing about walking through grief, she also wrote the Walk the Dog letter, which is Docket what, chat?
Docket 214, but every law nerd on the internet calls it the Walk the Dog letter.
Hi, Brad Bloodworth. Hello. Docket 214. For those of you that are like, Emily, what is that soundbite clip? Well, it's from the hearing where prosecutor Brad Bloodworth said to a witness, the Walk the Dog letter, Docket 214. As every law nerd on the internet knows, we see you, Mr. Bloodworth. We see you. We are the law nerds. This is a case where, as far as media goes, we have found ourselves mentioned in court once or twice when the court talks about there are these YouTube channels with insert exact number of subscribers I had at the time. I think it was like 817 or 820,000 subscribers talking about this case. Either way, Kouri Richins is accused of murdering her husband following an attempted murder about 2 weeks earlier on Valentine's Day and accused of poisoning him with fentanyl. Recently, we covered the defense filing saying a critical witness recanted their testimony, said that I'm not saying that anymore. I don't agree with that interpretation of things. The witness said, no, I sold pills to the go-between, and the go-between sold or gave those pills to Kouri Richins. But I said they were fentanyl. I don't know that they were fentanyl. They were probably just like Roxy's, which on the street probably also have fentanyl in them, but I don't think it's either here nor there. You sold pills to the go-between. The go-between gave them to Kouri. Kouri's husband ended up with more than 5 times a lethal dose of fentanyl in his system. Okay. I don't need you to connect every single dot. We're good. And that's after Valentine's Day, when Kouri Richins got a breakfast sandwich for her husband, and he ate the breakfast sandwich and then felt really sick and told his friends, "You almost lost me there. I almost died. Like I've never been this sick." And then there's text messages and Facebook messages of Kouri reaching out to the go-between and saying, "I need some stronger stuff." And then 2 weeks later, he died after the go-between went and got more stuff. So that's the Kouri Richins case in a nutshell. I'm going to keep drinking my coffee before it gets cold. So I know a lot about the evidence on this case because we have watched it since the bond hearing. And the sister-in-law, the victim's sister, came in and testified at the bond hearing. We watched the preliminary hearing. We've gone through quite a lot in this case. So if you're new, there's a whole playlist you can catch up on. And there's a second financial crimes case that is ongoing as well. This is a growing prosecution in the mortgage fraud, etc. So let's look at the court's order, and then we're going to have to look at the docket, and then we need to look at this interview and see if they're connected. I haven't watched this interview yet. If you have no spoilers, I like to first watch things with y'all. So we're going to do that together. But let's look at the court's updated ruling. This is from November 3rd, and we're going to take a look at that first. And then don't worry, we'll fly to Utah before we go to the interview. That's not my document. That's not my document at all. Hold on, let me refresh that so that it'll, I don't know, show up properly. Sometimes it just needs a minute. You know, the more I prepare in advance, the more I end up being like, wait, what? Why aren't you doing what I thought you were going to do? So it just needed to be reminded that we're actually streaming today. We're streaming. I know it's early. Even my third monitor is like, girl, who are you? Who are you? All right. November 3rd, State of Utah versus Kouri Richins. Yes, that does have her birth date in the year 1990. It's fine. We're just moving on. Updated ruling regarding motion to compel disclosure of Giglio material. So we are talking about the discovery of exculpatory information. Remember, we've got multiple motions covering this. I don't know why the judge is doing an updated ruling on this. We can always go back and watch the other ruling. Oh, Adam, I am streaming. Let's see. I'm texting Adam. For those of you that are like, wait, what? Do not worry. Adam does a Bravo focused channel up in Adam here, and we always have the best time together at BravoCon. I think he is traveling today. So let's continue. So I told him, I'm like, just come into chat and say hi. It's fine. We're streaming. We've got lots to do today. We've got a BravoCon day to have. Updated ruling on docket 818. But we also have the pending motions regarding the quote unquote redacted witness. And for all of you, Kendra B, this is exactly how I felt. Kendra B is like, she's younger than I thought. She's younger than I thought she was too. 100%. Which isn't fair to her because, when you're in custody, it's hard to tell. But yeah, she's younger than I thought too. So before the court is the defendant's motion to compel disclosure of Giglio material. Again, Brady material, Giglio material, Brady Giglio material. Some people will call it Giglio. Some people will call it Giglio, whatever. Exculpatory or potentially exculpatory information. Exculpatory / potentially exculpatory. Just, that's it. Just think of that. The defense was asking for a court order to compel the state to disclose any and all correspondence, notes, and witness statements connected to the investigation into statements made by Lieutenant Hemingway to any members of the county attorney's office on January 21st, 2025, relating to whether the team of law enforcement officers working on the Kouri Richins case was aware that she was represented by counsel in April of 2023. Remember, they were arguing that during her last interview before arrest, she was represented by an attorney and they didn't know, and they interviewed her anyway. I think this is kind of a nothing burger because they talked to her so much and she was just like, no, I'm going to chat with you about everything. Let me explain. So I think this is an issue for the defense. I think they have to raise this issue. I think it would be a huge problem if they didn't. I just don't think this issue is going to get very far for them. But that's what that issue is relating to. We looked at it later. It goes on to say, and whether the district attorney's office directed them to interview her, who they knew to be represented by counsel outside the presence of her counsel. Defendant's motion is based on and adopts by reference all relevant facts in defendant's reply and states opposition and reopposition. Or states opposition to reopen evidence for the motion to suppress. Look, if you are represented by counsel and law enforcement says, hey, we just have a few questions, you can respond, I have an attorney, please call them. Or I am disinclined to acquiesce to your request, please call my lawyer. You don't have to be rude about it. You can be perfectly polite. Hey, that's lovely. I have an attorney. Call them and we will set up a time. Or even just blame your attorney. My lawyer said that I cannot talk without you contacting them. And I pay them a lot of money to tell me what to do. So you're going to need to talk to them. And if they're like, are you sure you don't want to talk? You can say, no, I'm happy to talk to you, just not right now. I need my attorney and I pay them to tell me what to do. So I'm going to listen to what they do. And they said that you just need to call them. So call them. It's so-and-so and such and such. Just give them a call. And then they can set it up. Just blame it on the lawyer. The way that when I needed to bail out of something in high school, I just blamed my parents. Yeah, I would love to. Mom said no. So sorry. And then it takes you out of being in opposition. It's like, oh my God, I would love to help you. Terry, if you don't have an attorney yet, you can say, hey, I want to have an attorney before I talk to you. I want to have an attorney before I talk to you. And that's okay. You don't have to fight with them. I want to have an attorney before I talk to you. Give me your card. I'll give it to my attorney and then we can talk. I mean, they have the option to just arrest you after that, but then you haven't said anything and you haven't fought with them. You know, it's not dramatic. It's just, yeah, no, talk to my lawyer. You can also say, I want to talk to a lawyer first. That's fine if you don't have a lawyer yet. Kouri had a lawyer. Totally fair. Lawyer's daughter in the chat said, sorry, my dad said I have to call my lawyer. Who is now my son. I mean, right? Right? Susie said, say EDB told me I need a lawyer to speak with you. Yeah. I mean, there are exceptions to this, right? You witness a car accident that you're completely uninvolved in and you're like, that person did this and this person did that. Feel free. But if you're not sure why they're talking to you, they can explain it to your lawyer. Paula asked, can they arrest you if you want to speak with an attorney first? Yes, they can. If they have probable cause to arrest you, yes, they can. Like if they're coming out to arrest you and you don't know it yet, and they're like, hey, can we just have a chit chat? Chances are they already know if they're going to arrest you or not. The chit chat is icing for them. If they go in thinking they're going to arrest you, you talking to them is not going to undo it. They're going to arrest you either way. So you might as well not say anything and have a lawyer sort it out. That's it. So the defense has been arguing that at the time law enforcement went to Kouri's house, she invited them into her house. Hey, come on in, sit down. Can I get you something to drink? And they sat down, they're like, explain it to us. Kouri already had a lawyer. There was an investigation going on. This is a little less than a month before she's arrested. She's not arrested that day. She's in her own house. She could have, like vampires, she could have said, no, you can't come in. I mean, I guess it depends on the lore. She didn't. She invited them in, sat down, talked to them for all the time. And they're like, well, did the DA's office say go talk to her? Knowing she's represented by counsel, she could have said, I'm represented by counsel. Java time, this is a fair point. Ooh, a fair point. It's a fair point. Megan S. in the chat said, you can always talk yourself into an arrest, so don't talk. Yes, you're not going to talk yourself out of an arrest. That's not going to happen. Your lawyer might be able to talk you out of an arrest. You might be able to sort it out later, but in the moment, no. Not the time to sort it out. So they want to know if law enforcement in the DA's office talked about whether or not Kouri was represented by an attorney when they went to her house less than a month prior to her arrest. The court goes on to say defendant's motion is based on defendant's concern regarding the veracity of Detective O'Driscoll's testimony that he was not aware that defendant was represented by counsel when he performed the quote-unquote knock and talk interview of defendant at her home on April 14th, 2023. There was a hearing on this. We watched it. Court says, having reviewed defendant's motion, the state's opposition, and defendant's reply, the court rules as follows. Defendant has not shown that the veracity of Detective O'Driscoll's testimony is relevant to her Fifth and Sixth Amendment arguments. Oh, Your Honor, you punted. I'm not mad at him. I'm not mad at him. He punted. He 100% punted. Rando from Iowa asked, did he Mirandize her before talking? He didn't have to. He didn't have to Mirandize her. It was not required. And a lot of people will think, I'm really glad you asked this question. A lot of people will think, well, if they don't Mirandize me, I'm not a suspect. No. No. If they don't Mirandize you, you're not technically in custody yet. But you might still be a suspect. Ask Josh Duggar. Ask Kouri Richins. Suspect? She's a suspect. They didn't have to Mirandize her. I know. Rando from Iowa, I'm so glad you asked the question because I think that's a misperception that people think, oh, well, if they haven't Mirandized me, I must just be a witness. No. And the court totally punted. The court's like, I'm not determining the veracity of the detective's statement. I don't have to. First, defendant was not subject to a custodial interrogation on April 14th. No custodial interrogation, no Miranda needed. The court goes on to say, because defendant's counsel only anticipatorily asserted her right to counsel outside the context of a custodial interrogation, the detectives did not violate the defendant's Fifth Amendment rights by interviewing her on April 14th, 2023. She's going to be mad at this ruling. She's going to be mad at this ruling because I think Skye, her previous attorney, had sent an email to either the police or the DA's office or both. And we're like, hey, I represent Kouri. If you need to talk to her, talk to me. Like, talk to me, I talk back. The court goes on to say, second, Because judicial proceedings against defendant had not yet commenced as of April 14th, 2023, defendant's Sixth Amendment right to counsel had not yet attached footnote 2. The court made this ruling from the bench on February 21st, 2025 as part of a ruling denying motion to reopen evidence for motion to suppress. They hadn't filed against her yet. They hadn't filed against her yet. She didn't yet have a right to counsel. So they can come knock and ask her to talk. She doesn't have to talk. But they can ask. And that's what the court's saying. Accordingly, what Detective O'Driscoll or any other law enforcement officer knew or did not know regarding defendant being represented by counsel as of April 14th, 2023 does not implicate defendant's Fifth or Sixth Amendment rights. She had an attorney. Her attorney had reached out to a number of individuals and said, I'm her lawyer. If you need to talk to her, talk to me. And law enforcement rolled up to her house and was like, hey, Kouri, how's it? Can we chat with you? Can you tell us again about the night that your husband died? Thanks. We're going to record this real quick. You good? All right. Tell us what happened. They did not have to contact her attorney. They were not obligated to. So the court again is like, no, we don't need to take this up any further. Her right to counsel had not attached. It's not a custodial interrogation. It's an investigation at this part. Defendant had received a copy of the findings of fact that the state's outside counsel generated after investigating any possible inconsistencies involving Lieutenant Hemingway's and Detective O'Driscoll's reports. Excuse me. The state had an outside attorney in looking into the reports before trial. Utah is doing the most. Or maybe it's just that Massachusetts is doing the least, so it makes it seem like Utah is doing the most. But yeah, they had essentially a taint team to be like, hey, we'll take a look. They go on to say defendant fails to make a showing sufficient to support an inference, not even an inference, that the state's outside counsel, or law enforcement working this case have failed to produce exculpatory evidence, whether direct substantive evidence or impeachment evidence. Remember, in Massachusetts, they fought over whether impeachment evidence counts. Most jurisdictions don't. They're like, yeah, impeachment counts, turn it over. It goes on to say, for example, defendant does not point to any gaps or inconsistencies in the state's outside counsel's findings of fact or the state's disclosure of them. Finally, defendant makes references to various rules of professional conduct and argued that the February 21st hearing that violations of rules of professional conduct may require exclusion of evidence. That's not true. But defendant has not demonstrated that any violation of any rule of professional conduct has occurred relative to Detective O'Driscoll's testimony, or that any such violation, if it did occur, would require exclusion of any statements made by defendant on April 14th, 2023. Kouri wants that statement yeeted, and the court's like, yeah, no. No yeet for you. No yeet for you. None at all. Oh boy. The foregoing decision weighs in favor of ruling the defendant has not shown that the state or its agents have failed to produce information as required by due process, Rule 16, or the Utah Rules of Criminal Procedure. But one remaining issue prevents the court from denying defense motion to compel in full. What now? Why is there always a, oh, by the way? One thing. The notes generated by the state's outside counsel while performing her witness interviews. The state asserts that the state's outside counsel did not collect written witness statements or record witness interview. And the defendant does not assert otherwise, but the state acknowledges that its outside counsel took notes during her witness interviews. Defendant reasonably asserts these notes may contain purely factual statements regarding what any particular witness said. Depending on their content, such factual statements may have value as impeachment evidence. To protect defendants' due process rights while simultaneously protecting what may constitute core opinion work product of the state's outside counsel, the court conducted an in-camera review of the notes generated by the state's outside counsel. Look at everybody doing their work. Look at everybody doing their work. The defense raised an issue. The prosecution said, we don't think it's an issue, but you know what? We're going to get an outside counsel to come and do a bunch of interviews and figure it out. And they're going to take notes. And then the court's like, those notes might have information that's impeachment. That's not impressions. That's not work product. And so I'm going to read them all. And I'm going to figure out if there's anything in there that needs to be turned over to you. It's sad to me that it feels so good to see the courts doing the work the way that they should, with diligence and nuance. The court's not saying, yeah, turn it all over. The court's not saying, no, don't turn it all over. The court's saying, hey, I have questions. So let me do the work and then we'll decide. Where's my applause? Where's my applause, Your Honor? Where's the applause for the court?
That's suspicious.
Wrong one, Your Honor. It's not suspicious.
That's weird.
It's not this one. Look at that, everybody. The judge is like, let me help you. Awesome. That's what we want to see. The court conducted an in-camera, which means in chambers, just the judge. I went into the comfy chair and read it. An in-camera review of the notes generated by the state's outside counsel, footnote 1. The notes are control number, and those are, look at that. There are bait stamps numbers. The notes are bait stamped so that all the documents are sequentially stamped. The notes are controlled number state 186753009. No, that's not what it says. 1265845 through 1265859. They were provided to the court in a sealed envelope and have been preserved as part of the record that will be available on appeal. They're numbered, they're clearly identified, they were sealed, and they're being sealed for appeal, just in case. Look, everybody, when it works well, it makes it all look easier. Yeah? It goes on to say, excuse me, I was drinking my coffee too fast. Having conducted that review, the court makes the following determinations regarding the notes taken by the state's outside counsel, as referenced on page 2 of the state's opposition. 1, the notes do not contain any information that must be disclosed under Rule 16A1. 2, the notes? No, Emily, no. The notes do not contain material exculpatory evidence, neither substantively exculpatory, nor which may be used for impeachment, which must be disclosed as a matter of due process. Accordingly, the court determines the notes constitute attorney work product of the state's counsel that is protected from disclosure to the defense. You can't say that everyone didn't take a really good look at what was going on. The defense did their job, and in doing their job, they raised issues. The state said, we don't think those are issues, but let us prove to you that they're not issues. And then the court said, I'll review it and see if anything needs to be turned over. Fantastic. Well done, everybody. Good job. Also, the state went and got outside counsel to look into this issue. It wasn't only this, it was also the issue with regard to the walk the dog letter and more. I'm happy to see it, honestly. Really happy to see it. Good job, everybody. Happy to see it. The law nerds are just sitting here going, wow, look, it works when you work. You're doing the things you're supposed to do. But it raises the question then, what the fuck has gone off the rails since? And what is continuing to go off the rails in this case? Because when I was looking at the docket yesterday, I was going, what is happening? So we're going to look at the docket next, but we have a stream sponsor. So we're going to say a huge thank you to our stream sponsor, which may be familiar but different to many of you. And then we are going to take a look at this docket, and then we are going to watch this defense interview and see if that's what's causing all the problems. Because I have so many questions. So many questions. Hey, Law Nerd, I know that you share my love of cozy mobile gaming, but also sometimes we just want to figure out what's going on, which is why you need to check out today's sponsor, Paradise Paws, because you join Natalie and her sassy best friend, Lizzie. They end up on this island and there are animals left behind. And then there's a very cryptic note. And as you progress through the game, it starts uncovering new clues. As you play, you merge and unlock baby animals that are adorable. As you progress in rebuilding your sanctuary, what you find is greedy developers with some serious daddy issues are trying to claim your island. You'll need to fight back to protect your animals' homes before it's lost forever. One of the things I love about Paradise Paws is, yes, of course, it's free to download and it's ad-free so you can focus on your game, but it also works offline. And of course, there's a bonus. If you're one of the first 100 to install via our link or QR code, you'll unlock an exclusive baby penguin that will help you rebuild your sanctuary. You're going to gather resources faster and you can pick a name for it yourself. Let me know the name of your favorite animal and how did we even get on this island in the first place? So if you are ready to give it a try today and join your fellow law nerds in the fun, download Paradise Paws using the link in the description or in the chat and the QR code. And thanks to Paradise Paws for sponsoring this stream. Let's get back to it. I love seeing how many of you in the chat are like, I absolutely love this game. I absolutely am here for it. And for those of you that are just like, I also love Midas Merge, but I miss like the earliest days where you can just like scoot through things. I get it. It's really fun to be able to just scoot through some early gameplay again. It's lovely. So I hope that you enjoy it. Let me know when you get your animal. Okay. And everything's linked in the description. Let's go look at the docket. I'm pulling up the docket. We're going to docket together. Paula in the chat said, most fun. It's the most fun game ever, especially when they do the extra maps. I know. I love it. I love it. Trig said, damn it, Emily, this is just my kind of game. Goodbye, productivity. Look, it's a reward system for me. So I also at time put a timer on it because I really, really enjoy the casual merging games. They work with my brain. Love. We don't often do a docket dive together. It's been a minute since we've just pulled up a docket and done a complete docket dive. And that's what we're doing today. Docket dive. We're doing a docket dive. This is the docket in the Richins case. I'm not going to go all, wow, where did you go? Oh, no. No technology, no. No. Okay, that was the docket, the Kouri Richins case. Let's pull it up again. I was just about to say, I got recaptured. I was just about to say, I was glad I didn't have to go back to the top because it is such a extensive docket. You know what? It's because we didn't fly to Utah. It's because we didn't fly to Utah. That's why. So let me pull this case up again. The Utah docket is not on the inexpensive side. It is up there with some of the other ones. Los Angeles County remains, I think, one of the most expensive dockets, which is always frustrating, but it's also why I pull it up for y'all. It's also why I appreciate our sponsors, because the money we spend on dockets, but it's fine. I don't mind because I don't want y'all to have to do it. And I also am going to pull these up anyway. So I love it. I'm waiting for this docket to pull up. It is literally just Emily, you should have printed a PDF. I know. I just wanted to pull the whole thing. I really did. I just wanted to pull the whole thing. Here, we're just going to do it this way. There we go. Plaintiff, State of Utah, and their attorneys, Margaret Olson, Bradley Bloodworth, Joseph Hill, not Jonah, Joseph Hill, Byron Burmeister, and Lindsay, Chevernak. And then all the defense attorneys, Wendy Lewis, Kathy Nestor, Alexander Ramos. I don't know why they have Brad Bloodworth listed as a defense attorney. That's funny. He's not. They've got the charges listed, and then we're going to do a real quick scroll because we need to get down well past these early docketed items, and I'm not going to bother you as we scroll past hundreds of docketed items. We're in the thousands of docketed items now, so we need to get into those later docket numbers, and I want to make sure that we get right where we need to be. All right, June, July, October. Here we go. So as we get into the docketed items that we covered last time, we covered the motions regarding getting witnesses' attorneys. We covered the motion where the defense was like, this witness upends the entire case. Everything the state has said is fucked. Everything's changing. I don't see it that way, but that was their motion. That's where we are in the docket right now. So the date over here is, September 24th is the top one we were looking at. The motion to reconsider bail, we covered. And then things started popping up on the docket. The last time I pulled everything, these should have been on the docket, but they weren't. They just started popping up. Sealed. Ex parte motion for approval of defense costs. Fair. That is between the defense and the state of Utah and the rest of it. And they sealed that. You'll always see that motion to classify something as sealed. Well, not always. You will generally see it. We talked about the motion to compel on the sister-in-law. And then as we get down into this, we have a motion to classify documents as private from October 16th. And then we start seeing the rest of this. This is a proposed order to classify documents as private, and then they are classified as private. Affidavit and declaration of Brad Bloodworth, affidavit and declaration of Travis Hopper. Then we have the state's opposition for the motion to reconsider bail, which we covered. Then this is on October 20th. And again, these motions of Bloodworth and Travis Hopper may be related to the witness who the defense is saying flipped because they had those conversations. So in the your shit's flipped, those could be related to that motion with regard to bond, because there was stuff sealed in that motion. But then on October 20th, we have a motion to classify the state's motion for an order to show cause as private, and another motion to classify the affidavit of Brad Bloodworth as private. Orders to show cause are generally regarding, like the ones we're seeing in the Cardi B case. That one's over sanctions. But an order to show cause is a judicial procedural mechanism to say, hey, explain. It's literally an order to explain yourself. Excuse me. Can you please explain why, how, what the fuck? What we don't know is what this order to show cause is regarding. But it's what we're looking at now, because everything else that's going on, we've seen. We know that counsel got appointed for the witness, Robert Crozier. Fine. We saw all of that. We covered it. There is a sealed second affidavit of Brad Bloodworth the next day, October 21st. And then we saw that there were other counsels appearing. We covered that. Defendant's reply to the state's opposition to defendant's motion to reconsider bail. We talked about all of this. But there's another sealed motion to classify notice of supplemental authority in support of the state's motion for an order to show cause. That's on October 30th. We don't know what the OSC is about. What is the order to show cause and why? But then it gets even weirder. In between, so Docket 1092 is a sealed non-public information notice of appearance of counsel. So another attorney has filed an appearance, literally announcing their arrival on time. And then this is all on Halloween. And then in quick order, we have numerous sealed documents, including appearance of counsel, notice of limited appearance for attorney Alexander Ramos. Why does defense counsel have an attorney appearing on the record? I can only presume, and this is me presuming. Raina in the chat said, I didn't get a baby penguin. They will be sent to your in-game mail within like 3 days. They won't arrive today because once everybody downloads from the stream today, they will get sent out. So do not worry. Why is an attorney appearing for defense counsel Alexander Ramos unless it is regarding the OSC? Because that's the reason you would want to know. This is the reason you would want an attorney to appear. Just like Ron. Ron's like, hey, Your Honor, if we're having an OSC, I need my own attorney. So now we have an appearance of counsel for attorney Alexander Ramos, defense counsel, and then the motions to classify this as sealed. And then someone filed non-public information privilege communication, which could be a lot of things. It could be communications between attorneys. It could be attorneys and clients. But there is some type of privilege communication that is also sealed, all on the same day. All on the same day. Still on the same day. There is a motion to classify attachment 2 to the state's Rule 16 witness and exhibit disclosures as sealed. I think those are related to Docket 1102, which is the state's witness list. I don't think these two sealed documents have anything to do with that order to show cause. Then, the same day. This all went down on Halloween, the same day. There is another privileged communication motion to strike filing of appearance and remove from the court docket. So they are not just striking the appearance, they're removing it from the docket. This appearance up here. This appearance of counsel. We still know that it's an appearance of counsel for defense counsel, but the filing has been stricken and removed from the docket. And then the court issued an order on November 3rd that's just completely private and sealed. I can only imagine that it's relating to all the stuff above. Because granting a motion to keep a witness list sealed is, hey, we're sealing the witness list. That's not a big deal. Then, also November 3rd, there is a non-public information memorandum in opposition to the motion for an order to show cause. What is happening? Lucy in the chat said, is Ramos the paramour? Hopefully not, because Ramos is one of the defense attorneys. So no, I'm joking. That was a joke. Ramos is one of the defense attorneys. He's the dude that always has to deal with the tech, with the glasses. So then there's an opposition to the order to show cause. I don't know what the order to show cause is regarding, but it's all being filed at the same time that defense counsel is having an attorney appear on their behalf. So then, on November 7th, there is another motion to classify the state's reply in support of its order to show cause, and then they're asking the court for a decision on the order to show cause on November 7th. And it's all sealed. All of it. But even though they sealed, we know that there's an order to show cause. We know that the defense attorney has an attorney appearing on his behalf. I can only imagine that it's related to the OSC. I can't imagine why else the defense attorney would need an attorney to protect his rights. Other than it's regarding the OSC. So there is a limited appearance here. And all of this goes down after the defense attorney's interviews. I do not know if they are related. They are close in time. And you have two affidavits of the defense attorney, of the prosecutor. However, this is also close in time to when the defense filed all their motions regarding the witness. Crozier. Could it be that it's related to that witness? Yes, it could. So if witness Crozier had the conversation where he quote unquote recanted with attorney Ramos, that would be non-public information because that's the defense attorney talking to a witness. That's work product. And if somehow it is being alleged that the defense attorney misstated what the witness said or something, that could also be a situation where the defense attorney is like, no, bring my attorney in. So it could be related to the quote unquote recanting witness interview. It could be related to the television interview. It could be either. So we're going to watch the interview and see if anything in the interview strikes us as interesting. But before we do that, sorry, ADHD curiosity. But before we do that, I'm going to pull the defense attorney's motion. Chat, will you give me a moment? I'm going to pull the defense attorney's motion. I wonder if in their motion regarding Crozier, if it says that the interview was with Ramos. I want to answer that question because I don't remember clearly. Let's look at it together because it could be either. But something's going down. Something's going down. This is the witness. Oh, no, this is the motion for discovery. Wrong one, Emily. Wrong one. It's going down. I'm yelling timber. I want to know. I want to move. I want to. Emily, is this what you're like when you're researching without chat? Yes. Yes, it is. Yes, it is. Where is that motion? There are too many. I think it's in this one. Optimistically. If it's not, we'll go look at the other one. And then we have to look at this. Then we have to look at this interview before I have to bump to a appointment. Let's see. This is them talking about the headlines. Let's see. Crozier was interviewed by 2 members of Summit County. When was he interviewed by the defense? Let's see. Where do you say when you interviewed him? I do not. Let's see. Let's see if we can find where they talk about the defense interviewing Crozier. Because there are like 3 interviews we're talking about. Let's see. Defense looked within the discovery folder provided. There was no information about this. Prosecution was aware. Mr. Defense counsel located and interviewed Crozier within the past 30 days. Okay, so they don't say which defense counsel. Let me look for Crozier's. I think Crozier's affidavit is in the next motion. Let me see if his affidavit says who he was interviewed by. Because I'm super curious. Soup's curious at this point. And I want to make sure that if it could be both things, we have that answered for our brains. So let's look at Crozier's statement real quick. Because Crozier says he was interviewed. He was interviewed by Summit County. He doesn't say who he was interviewed by the defense in that one. Let's see. I was interviewed by Summit County. I don't remember the details of the interview. Currently in recovery. He does not say who from the defense interviewed him. So we're still with 2 distinct possibilities. Is it regarding this witness statement? Or is it regarding the TV interview? Or is it a little bit of both? It would have been so much easier if they just said who interviewed him. But no, they say defense counsel. But only one of the defense attorneys has an attorney that has appeared on the record, which is also interesting to me. All right, we're going to take a look real quick. Well, not real quick. It's about a 20-minute interview. This is a segment with KUTV. This interview took place, let me see. I'm going to pull the date up real quick before we go to this. October 15th. October 15th, this interview was put on YouTube. I do not know if it aired locally in Utah prior to that or same day as that. 5 days before this flurry of motions with regard to the order to show cause. Would I be surprised if an order to show cause was filed over an interview when the court has put a lockdown on talking to the media? No, I wouldn't be surprised. When I saw that there was an interview, I was like, ooh, the prosecution's going to be pissed. Gonna be pissed about this. So let's take a look together. We should swoop. We should swoop and we should interview. So law nerds, let's take a look. Let me make sure the volume is like on. It wasn't, it was muted. And let me make sure closed captioning is on. It wasn't. There we go. For those of you that have watched the interview, thank you for no spoilers. For those of you that haven't, I haven't either. I'm going to try to go through it smoothly without stopping too much, but it's me. I make no promises. Let's take a look at this set that they seemingly constructed for this interview.
In an unprecedented move,
we were willing to take an unusual step of coming forward.
Look, I need to move the closed captions. Come on, closed captions. Somebody's face is going to get blocked, but I like having the closed captions. Also, I will make my beef be known with the way TV films things and the angles that they use. I just hate it. It doesn't need to be so dramatic, everybody. We just want to see people's faces while they're talking. Mr. Ramos has very nice glasses, but I don't need to be able to like read the temple length of his glasses. I don't need the extreme close-up.
I never thought I would be sitting here.
Kouri Richins' attorneys.
She is just
the green screen. The green screen is sending me. Oh my God.
Forward.
Look, I never thought I would be sitting here.
Kouri Richins' attorneys.
She is distraught. She is heartbroken.
Reached out to 2 News Investigates.
I don't understand what this camera angle is. I really don't. I really don't understand. I don't.
Exactly why we came here. And really, it's an ethical duty.
We have a lot of confidence in you.
To set the record straight.
One thing that's been reported on that they have let go, have not corrected.
If their goal is justice.
The music is I like his tie. The music is giving crime documentary. So, yeah, the attorneys reached out to the news. The attorneys reached out to the news. Yesterday, I had a whole conversation about why I don't often speculate. Today, we're in BravoCon mode. Today, we're just...
Mention it all. Mention it all.
BravoCon mode. We know that these attorneys have watched, paid attention to the Karen Reed case because they've talked about it. They used the experts from the Kohberger case. They, in my opinion...
That's my opinion!
Stole this move from Reed's defense team. Reed's defense team went proactively to the media. They stole this move from Jackson to try to correct the record. That's my speculation on it. Purely my speculation. But we've heard them talk about the Reed and Kohberger cases in court. And they are trying to bridge what I wonder if they see as the new, defend someone in the court of public opinion as well as defending them in court. These cases are very different. These attorneys are very different. And this judge is very different. So I don't think this is going to have the same impact, but let's see. I haven't seen this interview yet.
They have not lived up to
my
it.
bad.
At least in this case.
Sorry, Mr. Ramos. I didn't mean to step on your statement.
Let go, have not corrected.
If their goal is justice, they have not lived up to it, at least in this case.
A 2 News exclusive.
And I feel that when I see these narratives come out, it becomes a game. It becomes another line. And we forget that there's somebody on the end of that, and that's a client.
I don't think we've
That's a
forgotten
human.
that.
That's a mother.
A Camas mom charged with murdering her husband.
The narrative is that you're
Chat, a lot of you in the chat are mothers. A lot of you in the chat are parents. I don't think the you're a mother just is exculpatory to all wrongs that might have happened. I didn't agree with it when Jen McCabe is like, we're just normal soccer moms. Okay. So you're a parent. And I don't understand but she's a mom. She would never. Are you fucking kidding me? Sir, we don't think people would do or not do horrible things just because they may or may not be a parent. That's not. Yeah, chat. All of you are pointing out Donna Adelson, Sarah Boone, but they're a mother. Lori Vallow Daybell, exactly, but they're a mom. And it doesn't make you a good person. Humans do wild shit because they're humans. But the sympathy card of, but she was just a mom. I'm so tired of it. I'm so tired of that narrative. I'm so tired of it. Okay, I'm done now.
client is the Moscow Mule murderer. Is that accurate?
A narrative of alcohol, drugs.
Who is calling her the Moscow Mule murderer? Also, chat, where did the media get these photos from? From Kouri. They're getting them from Kouri. These are photos that she, through her attorneys, are providing to the media. Keep that in mind.
Drugs and greed.
There are certain things that are out there that we know right now, sitting here today, just aren't accurate.
And her attorneys say false information.
I do think the prosecution has declined to correct false information that has come out in the media. And
I was going to try not to pause as much. That's not their job. They can't respond to information in the media. They can only file documents.
we've waited and hoped that that would occur, and it never has.
Tonight,
They're not gonna do
Richins'
that.
attorneys speak out only to 2 News investigates.
That's a very, very
Also, I have no shade to KUTV. If the defense attorneys in this case reach out to you for an exclusive interview, the media, you take it. You 100% take it. But it's not the job of the prosecution to say, excuse me, media, she said there was a Moscow Mule and a lemon drop. We can't be sure it's the Moscow Mule. Even though in one of her interviews, she told police that that's what she made for her husband. But we can't know. There was also a lemon drop.
different narrative.
Camas, Utah, a small town in Summit County with about 2,000 residents. Among them, Kouri and Eric Richins and their 3 boys.
Their family was so beautiful. Everything was picture perfect.
Linda King used to work with Kouri Richins at Home Depot and remembered Eric, who was a contractor coming into the store.
You could never forget his laugh. And I love that laugh so much.
Linda says she encouraged Eric to ask Kouri out after she caught his eye.
I says, go over there and check out with her, so they did.
I really wish this wasn't a case about an attempted murder and brutal murder of this victim. Because otherwise, it's a really cute story. How many of you have worked cashiers as retail? People ask me out all the time when I was working cashier as retail. I mean, people ask me out of the DA's office too, which was weird. I'm like, I am married and pregnant. Why are you at what? But it would be a sweet story if it didn't end the way it ended. Also, not a bad strategy. Working at Home Depot, chatting with the contractors. I Not a bad strategy. Not a bad strategy. We love a partner that's not afraid to drywall. Love it. Love it. The craft, which Rachel said, EDB, I worked retail at Michael's. Grannies with their yarn wasn't asking me out, but were they like, oh my God, my grand would just love you. Can I? Come on. This is a solid strategy. I like it.
Anyway, they ended up having a date. From then on, they were like,
these are all new photos.
You know, it was perfect, I thought.
Perfect until
Nothing is perfect. Nothing is perfect. Nothing is perfect. And when you see people saying, oh my God, their marriage is perfect, it's probably worse than you think. Because when marriages are pretending to be perfect, it's a problem. I find that when people feel settled, if they disagree once in a while, they're not afraid that you know that they disagree because they feel settled and confident. So.
on March 4th, 2022, when Eric was found dead inside the couple's home.
These are photos we have not seen before.
Police originally ruled that there was no foul play in Eric's death from fentanyl. Then a year and 2 months later, things changed.
Chat remembers why things changed. Because they got into her cell phone. It took that long to get her cell phone. This is your regular reminder. If you don't want people getting into your cell phone, you need a longer passcode.
On May 8th, 2023, Kouri was charged with her husband's murder. Prosecutors have added additional counts of financial crimes as well. As of today, Kouri's charged with aggravated murder, attempted criminal homicide, 2 counts of insurance fraud, and forgery.
Wendy Lewis, and I am lead counsel in the Kouri Richins case.
Well, that clears that
Kathy
up.
Nestor, I am one of the attorneys on the Kouri Richins case.
Alexander Ramos, co-counsel on the Kouri Richins case.
Wendy Lewis, Kathy Nestor, and Alex Ramos took over as Richins attorneys in May of 2024 after her previous attorney declared a conflict in the case.
What we came in here today were to focus on 4 very serious areas.
They have their talking points. They have their talking points.
That have been absolutely factually reported incorrectly and that have been discussed publicly in court, in open court. I do think the prosecution has declined to correct false information that has come out in the media.
If the prosecution tried to do this and did it in a way the defense didn't like, I imagine that the prosecution would get excoriated. Your Honor, they're talking to the media. The defense is allowed to respond, and she is laying the groundwork for this. She is saying, we are not going on the offensive here. We are correcting a narrative. We're responding to things that happened in court. We're allowed to answer back. That is the way that they are going to say that this is fine. And this might not be the subject of the issue. It might be.
Media, and we've waited and hoped that that would occur, and it never has. And so that is why now, at this moment, at this time, we're coming forward and saying, well, then we're going to correct it. So that's where we are, and that's why we're here.
First up,
The narrative is that your client is the Moscow Mule murderer.
That is so
Is that
terrible.
accurate? Can you confirm what the murder weapon is?
I can't confirm what the murder weapon.
Kouri told police that she made a drink for herself and her husband, and then she went to bed. And then he had more than 5 times a lethal dose of fentanyl in his system. And there was no fentanyl found anywhere in the house or near him on the bedside table. She said she didn't touch anything. She said she didn't move anything. And there was there was nothing found. And then she said it must have been the weed gummies. It must have been the edibles. And the edibles were tested. They didn't have any fentanyl in them. So the murder is by fentanyl poisoning. I don't really care if it was in a Moscow Mule, or if it was in a lemon drop, or if it was in a glass of grape juice. I don't really care.
Is because the prosecution has never told us their theory. They have never said.
Their theory is that she gave him fentanyl in a breakfast sandwich on Valentine's Day and then gave him fentanyl in a drink that she made before bed. That's their theory.
That it was given in a Moscow Mule, that fentanyl was distributed or in a Moscow Mule. During the preliminary hearing, their lead detective was on the stand, and I asked him the question, sitting here today, do you know how Kouri Richins administered fentanyl to Eric Richins? And he said, no. The prosecution has never said that it was in a Moscow Mule. That came up because there was discussions, and I believe a statement by Ms. Richins early on, that she and her husband had drank a Moscow Mule before dinner. So that was something that was just grabbed onto. It's sexy, it's interesting, the Moscow Mule murderer, but the prosecution has never said that that is their theory of the case, not once. I still, sitting here today, don't really know how they're going to claim that Eric Richins ingested fentanyl.
Does the prosecution have an obligation to?
I can tell you, they're going to claim it was in a drink that Kouri made for him. That's what they're going to say. They're going to say it was in a drink that she made for him.
Correct the record, the public record of this.
No.
I mean, it's the prosecution's job to bring justice. That's what you do as a prosecutor.
It's not their job to talk to the
protect
media.
Your client's right. A prosecutor needs to find justice, fight for justice. And I believe by not correcting the record, by letting falsities sit out there, that's not what is happening. Now, we'll see what happens in the courtroom, but that.
The jury is not going to like the way that the defense is trying to parse, well, we don't know how it got into his system. It defies common sense. Because she said in multiple interviews that she made him a drink. So, Minnie said, couldn't this be tainting the jury pool? It could. It could, but the defense is going to say, no, we're trying to correct the narrative. The wrong narrative is tainting the jury pool. We know that they think that because they filed their motion to change venue. They think the jury pool is tainted. And I'm sure they're like, this is our job. We've got to correct the record. We've got to push back on the Moscow Mule murderer. I hate giving cases these abhorrent nicknames. Utah versus Kouri Richins. She's the one that wrote the Walk the Dog letter, wrote the children's book. Doesn't need a cutesy name.
In our view, is something that they should have corrected.
Can you confirm then that the fentanyl was administered in the Moscow Mule, given what you just said about the lead detective O'Driscoll? He couldn't confirm it, correct?
We cannot confirm what their theory is. We believe Ms. Richins is innocent. And, we're not here to convince you or anyone else that she's innocent other than those 8 people that are in the box at the trial. Those are the people we need to convince that she's innocent. So that's not why I'm sitting here, but we do want what is accurate to be out there. A lot of it will come out at trial, but there are certain things that are out there that we know right now, sitting here today, just aren't accurate. And the Moscow Mule appears to be one of them. Now, since they have not ever said to us exactly what they think their theory is, I suppose we could be surprised at trial and they'll say, oh, it was the Moscow Mule after all. But they have never stated that in court, ever, or in any pleadings or in any way.
The prosecution has painted your client as the Moscow Mule murderer. What is your opinion?
I disagree with that question. The media has made that name. The prosecution hasn't. But Kouri's interviews talked about making him a drink. I'm going to just stop arguing
on that.
The Moscow Mule has never been stated in open court as being used to cause someone's death. I'm not sure where the press came up with that, but the lead detective has testified under oath that as of now, he does not know how fentanyl arrived in Mr. Richins' body. And
Mr. Richins didn't administer it himself. So that's really all you need to know. This is not the serve they think it is.
And so the press claiming that there's a murder weapon, that this was it, is just wholly fanciful. It just didn't happen.
He didn't accidentally end up with 5 times a legal dose of fentanyl in his system by accident in this case. Unless the messages that we've seen don't come in at trial. When there are overdoses, normally if the person has accidentally OD'd, you see the thing they accidentally OD'd on near them. That was not the case here. There was no fentanyl in the entire house. Do you know what that says to me? It doesn't say to me she flushed it. It says to me she gave it all to him. The jury can come up to their own conclusion on that. We'll see. But we've got all the messages of her buying it and asking for something stronger. This was not an accidental OD.
And it's not ever been said by the prosecution in this case, and it's never been in a pleading in this case, and it's just inaccurate.
Second, was Kouri in financial distress because of her real estate business? Prosecutors have said at the time of Eric Richins' death, K. Richins Realty owed hard money lenders more than $1.8 million.
Kathy, before this, was your client solvent?
So that's one of the issues we felt compelled to speak to the
Oh my
press
goodness.
about. There has been quite a bit of reporting about my client's financial situation.
Her wording's very careful about this.
And the concern that we have is that the reports that have come out about her business, the solvency of her business, utterly fail to take into consideration a huge piece of property that she obtained 2 days after her husband passed away. And that's...
Was she solvent at the time of the murder? Well, they forget to take into account this property that she took possession of 3 days after the murder. She was leveraged beyond her means. And we've seen her loan servicing. She was paying tens of thousands in loan servicing. But okay. Also, that property was a massive liability. It was not an asset. Very careful wording.
Removed from all of the state's calculations. So the equity in that house
There was
alone, the value of that one piece of property was enough to cover any debt that she had in her business. And we just feel that that is improper reporting, that arbitrarily cutting off what condition her business was in prior to her husband's death without taking that into consideration is misleading. Furthermore, all of the reporting that is done only focuses on what we call debt service, not the actual value of the property she held. So that's completely being kept out. So it would be like if they said, you know, Ms. Halloran, what is your net worth? And you left out your house. I mean, that's a piece of property is an asset and it has value, and that's never taken into consideration. And so we believe that that has also been misreported, and that's something we felt ethically compelled to come forward and correct.
Third, life insurance.
Well,
oh my
another
God.
one that's out there's false is that she took out
Disagree.
hundreds of thousands of dollars in life insurance on him shortly before he died. That's not true. She took out one policy that came in the mail, and it was one of those mailers we all get from our credit unions saying, sign here for $100,000 for your life insurance.
That's not in evidence anywhere.
Sign here for yourself, sign here for your spouse. You can get $100,000 for your life.
This information is not known anywhere. This is not, hey, in court documents we said this. Hey, in court documents we said this. This is adding additional information. This is something that if you want the jury to know, the jury has to know. But this was not the only policy. But okay.
Insurance. That was sent in. She sent that in about a month before he died, 4 or 5 weeks before he died. all the rest of his life insurance, and he had a lot of life insurance, was all taken out by him long before that. And he knew of all the life insurance policies that were out on him. And we don't know if he knew of that last one. But in terms of her taking out a life insurance policy on him, that's the only one, $100,000. So their motive, according to the state, is, oh, she took out life insurance, she was going to cash in on all this money. And again, that's not accurate. I mean, she took out an extra $100,000, which may seem like a lot to a lot of people, and it is a lot, but to this family, the other life insurance was well in excess of that last $100,000. And that amount of money for this family was not really all that much.
Does the prosecution have an ethical obligation to correct these things that are out in the narrative?
No. The prosecution has an obligation to put accurate things in the court filings. It is not their job to, actually, the media, and be like, well, actually, Kouri said she made a lemon drop and a Moscow Mule. We don't know which one Eric drank. That's not their job. That's not their job. Oh my God.
Again, I think if what they want is justice to be served, they have an obligation to do that. Of course, they're real.
She didn't answer the question, did she? Do they have an obligation to do that? No, they don't. But if they want justice to be served, they would correct the media.
Nope.
This isn't going to help. We're just getting a preview of what they're going to try to argue at trial. And these arguments, given what we know about the case, unless the evidence comes in very differently, this isn't going to fly.
Obligation is in the courtroom, and we'll just have to see what happens then.
And the final point? The Google searches regarding how much fentanyl it would take to kill someone.
There are a number of things. You talked about the Moscow Mule, which we believe is not their theory. They've never said it was their theory. And I think the facts that come out in trial will make it very obvious that that isn't even a possibility. But one thing that's been reported on that they have let go, have not corrected, is that Ms. Richins Googled how much fentanyl does it take to kill someone. And that's been in the press, and it's been...
I've never seen that, by the way.
And extrapolated from that she Googled that before Eric Richins' death. And that's just not the case. We've discovered through court records, through exhibits, that she Googled how much fentanyl does it take to kill someone.
There were also spelling errors in these Googles. There was a how's much. There were some spelling errors in these Googles too, but the how's much fentanyl is never going away. Ever.
A day or two after she was told he died of fentanyl poisoning, not before, which makes perfect sense. She doesn't know how her husband died. She's told, your husband died of fentanyl poisoning, and she's looking, well, what does this mean? How much fentanyl would someone have to take to die of fentanyl poisoning? That's a very, very different narrative than to leave it out there that, oh, the Moscow Mule murderer Googled how much fentanyl does it take to kill someone. No, that's not what happened.
One thing that's also been different in this case for the attorneys is how the prosecution is handling it.
The language that the prosecution uses in its filings, do you feel at any point that they have crossed the line?
Yes, this has been interesting. I have not seen the personal language in filings typically in court that we're seeing here. The prosecution...
Okay.
...does seem to have a very strong opinion on this case. Not just, here's the evidence. They seem to have a personal opinion, which I think is reflected in their pleadings and has been reported on, some more than others. The poppycock memo was one that got reported on, which is surprising and unusual.
They keep talking about things that have been reported on when we have covered this case filing by filing almost. And there are things that I have no idea what they're talking about. Walk the dog, yes. Who said poppycock? Also. Why is that a phrase? Also. The defense language has been significant. The defense hand-wringing, and it started before these attorneys came in. But the defense hand-wringing in this has been significant. And Brad Bloodworth is like, oh, shade is what you would like? Let me provide it for you.
To see language like that in legal pleadings. So we've been uncomfortable with that. I see the prosecutor's job, like I said, is to fight for justice. It's not personal. It's not personal for them, and it shouldn't be personal for us either. We're all there doing our job. We're there to protect our clients' rights.
Yes.
We're there to make sure our client gets a fair trial.
And they're doing that.
They're there to serve justice. And what they think is justice and what we think is justice is very often the opposite.
That's fair.
But it begins to get personal sometimes, I think, when it's a case that it is high profile. There is a lot to it. They've been working on it a very long time. And, I can see that sometimes you can't help but get personal. Sometimes we can't help but feel personally upset about our clients. It's hard. It's a job, but it's hard. Some prosecutors are better than others at not making it personal. It's just been my observation, and maybe I'll be proven wrong at some point in the future, but this has become quite personal for them.
Interesting.
So why did the defense attorneys come to 2 News Investigates? Why now? Why not just correct the record at trial?
Look,
Why now? Why this interview?
never thought I would be sitting here. I don't think I should need to talk to the media. I really believe that I should be able to get a fair trial. But the way that this case has gone.
Oh, so you guys do want to talk to the jury pool. You do want to talk to the jury pool. That's the point. The point's to talk to the jury pool. I would like to think we can get a fair trial, but if we can't, we'll just talk to the media now. He does. I agree. He looks super uncomfortable.
I don't think we can do that. We have to make sure that when we step in there in February, that we have leveled the playing field, and we can't just hope for that.
Is that why you came to me?
That's exactly why we came here. And really, it's an ethical duty. There's a rule.
Listen to what he just said. We have to level the playing field. We have to level the playing field.
Rules of professional conduct that says if we think that there are facts out there that have been laid out in such a way that we think goes against our client's best interest, that we have a duty to come out. I think some defense attorneys do hide behind, hey, I'm just not going to speak, no comment. And I think that's fair. I do it a lot. But this is different.
Because we don't get an opportunity to argue the facts until we're in front of a jury. The judge decides the law, a jury decides the facts. And what's in the narrative right now and in the public media is facts. So we won't have that opportunity until we're at trial and the jury is sitting in the box. And like I said, our concern is, can she get a fair trial when all of this is out there before?
So they're trying to provide another side, they say, to what's in the court filings. Put it in the court filings. Every time the prosecution files something, you get to respond.
Or we ever get an opportunity to show our side of the story and to show what we believe really happened in this case.
What do you believe happened? The judge is going to hate this.
We believe that she's innocent. And the rest will come out during the trial. Because like I said, it's the people in the box that we need to convince, not the viewers, not anyone else. We just want to make sure that people don't come into that trial believing things that are absolutely false. We don't want to...
If they come into the trial believing things that are false, you do not seat, you immediately yeet. The court said he was comfortable, and a lot of judges won't go this far. The court said he's comfortable yeeting every single person who has heard about this case. He's like, I'll just kick them all. Why don't we just kick every juror that's heard about the case? And a lot of prosecutors wouldn't say, well, that's fine. A lot of prosecutors would say, well, Your Honor, if they say they can be fair, meh, 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 meh. And the prosecutors here were just like, yeah, fine. Sure. We're down. Absolutely. Why not? So the prosecution and the defense agreed. And the judge is like, here's what we do. Kick everyone that's heard of the case. That's it. Problem solved.
Spend the time in the trial convincing people that what they've already heard is wrong. We want to spend our time, presenting our case without having to go back and argue against what's in the media.
Is the prosecution in this case injecting a false narrative to the media?
I don't know if they're necessarily injecting it, but they're certainly not correcting it. And I think that's why we're here today, is we honestly feel that we have an ethical duty when we have a client who is facing such serious charges and there is misinformation.
Did Kouri tell you she wanted you to talk to the media? Is that why it's all sealed? Is it that your client was like, you need to go do this?
Out there, and it is not being corrected. It's a disservice to justice.
With that said, then, how critical should the public be with this narrative? Or is the public just taking the prosecution?
Just go watch the preliminary hearing.
Statements and narratives at face value because it's the prosecution.
Why do we keep saying narrative? There's just filings and there's a preliminary hearing. It's not a narrative. Is this a walk the dog? You need to go tell them.
The state of Utah.
I think that's part of it. I think also it's easy because of the headlines to just go along with it. And when somebody who we trust, right, the county attorneys throughout this state, the district attorneys, we trust that they're going to make the right choices when they charge. But also, it doesn't end there. It's also through the prosecution of a case. And with such a high-profile case, I think the public needs to be even more critical.
I know this might be the most high-profile case you guys have been involved with, but we're not even close. And the reason it became high-profile is because your client wrote a children's book about grief, saying that she had lost her husband. And then it all came out that she had, as alleged, tried to poison him on Valentine's Day, asked for stronger stuff. Then he died 2 weeks later. At the same time, she was texting her side piece that they're going to be together soon. And then she did attack physically her sister-in-law when the sister-in-law went to the house shortly after the death. And that all came out in the bond hearing. But her writing the book was why this was in the public's attention.
Because if what's going on in this case goes on to a lesser degree in other cases that don't get the exposure.
Sir, you have not even begun to see the fuckery that is happening in other cases. The fuckery is not here, sir. There are some sassy footnotes, but this is not the fuckery you're looking for. If this is what's happening in this case, imagine the other cases. Sir, we can imagine the other cases. This is not the fuckery. It's sass. And you have a fantastic judge.
That don't have the appropriate, resources. That's when our country starts to become in danger.
And if I may ask you this, I'm not sure if you will answer, but has the Summit County Attorney's Office vilified your client?
It's not their job to either vilify or create or make them insane, but it is their job to stick with the facts. And that's something that they have not done in this case, especially with how it's been portrayed in the media. If their goal is justice, they have not lived up to it at least in this case.
I'm going to need
Why
some
reach
facts
out
on
to
that.
2 News investigates?
I don't know. I mean, we have a lot
Is this going to turn into just a glazing sesh
of
here?
confidence in you.
Why reach out to us? Oh, because we love you. We love you too. Oh my God, no way. Oh my God, yes. Why reach out to us? Is it because we're the best? Oh gosh. Oh gosh.
And we're hoping that you can get the word out and that
There it is.
it's
We're hoping you'll get the word out.
Out to 2 News investigates.
I don't know. I mean, we have a lot of confidence in you, and we're hoping that you can get the word out and that it's kind of the one pebble in a pond, right?
Because you guys have most of the headlines. KUTV is covering this the most. We need you to get the word out to the potential jurors, please.
That once you throw a pebble in and the waves spread out. And we're hoping that once we correct it in one place that's credible, that's a well-known news source, that maybe the other news sources will also start to question a little more about what they're hearing and what they're covering, just so that the importance is that the facts that are reported accurately. And we really appreciate the opportunity to come forward and correct what we think has gotten out there incorrectly.
When you hear these false narratives and you know who you believe to be,
There's just a voice from the ceiling. There's just a voice from the ceiling.
It's extremely frustrating. I think being a defense attorney, being a judge, a bailiff, it feels routine. You possibly in your job when you're doing things feel routine, but you're doing so much in your job that means something. And it's no different in the courts. When we walk in, we joke around, we know everybody. At the end of the day though, we're doing something very special in there, every single hearing, and especially when we're in trial. And what we're doing is we're upholding the Constitution. And that's a very high bar. And I feel that when I see these narratives come out, it becomes a game.
I don't think the prosecution's turning this into a game. There has been some top-level dramatics from the defense as well. So if the defense thinks they are going, and this, look, they came into this case midway through, but if the defense thinks they are going to just lob shots and it's not going to be answered, it's going to be answered. Mr. Ramos, I like the tie. We're all big fans of justice. But maybe look at the media and be like, why are we nicknaming shit? Also, this judge is already on the verge of not allowing cameras in this case at all. I think if what you're saying is true, if what you're saying is your client is going to be proven innocent at trial, y'all should be pounding the table to have cameras in that courtroom and streaming. But this is going to push the judge in the other direction. And all 3 defense attorneys have said, we are doing this to push back on what is out in the media. The prosecution has put out court filings, not press conferences, not press statements, filings. And they're saying, nah, we're pushing back on the narrative.
It becomes another line, and we forget that there's somebody on the end of that, and that's a client. That's a human. That's a mother.
And a victim, and a victim's family, and the children of the victim. Yeah, there's more there.
And it does really frustrate me.
is Kouri aware of these narratives, and how does she handle?
It sounds like somebody is chiming in from the back. The question is Kouri aware of these narratives, and how did she handle that? She gave a podcast interview by jail calling and wrote a walk the dog letter.
What you claim is misinformation being spread about her?
She is distraught. She is heartbroken. This has been very, very difficult for Ms. Richins. She's been in jail now for over 2 years on these charges and doesn't have an opportunity to really tell her story until we're in trial. So yes, it's been very difficult on her.
Is Kouri going to testify? Is Kouri going to testify? She doesn't have an opportunity to tell her side of the story until we're in trial. Sounds like Kouri's planning on testifying. The music
I
is
asked
so
Summit
dramatic.
County Attorney Margaret Olson and Chief Prosecutor Brad Bloodworth for an on-camera interview for this report. I received the following statement. We are aware of the recent filings submitted by the defense. We will address all matters related to this case through the legal process rather than in the media. Our formal response will be part of the public record next week. We ask that this comment be included in your report to ensure our position is accurately represented and the reporting remains balanced.
Are those all the sealed documents, though? Because everything that came in the following week, there was stuff that was responding to the witnesses recanting, but then everything else is sealed. All right. I love that the end of the video is recommending my own video and then famous last words. Emily, how quickly can we get yeeted off the platform? Well, I know. No, Emily, no, do not. One of my favorite MCR songs. Brain, stop it. A number of you in the chat are pointing out, notice that the media didn't show on the screen the second part of that quote. Correct. I'm trying to rein myself in from singing loudly because I have got to get going. I'm not going to have a ton of time for questions. Let's try to summarize what's going on here. There is a lot brewing in the Kouri Richins docket. Most of it is sealed, including the prosecution's request for an order to show cause. Remember, that is the order to explain. We don't know exactly what is going to be explained, but we do know that defense attorney Ramos has an attorney that has filed an appearance on the docket, and then that appearance was made completely sealed and all the documents were taken off of the docket, but the title stands. That could be related to conversations attorney Ramos had with Kouri Richins, because there are privileged communications. It could deal with the quote unquote recanting witness. If Ramos is the one that sat down with the witness who said, no, I never told law enforcement. I told law enforcement, or I don't remember telling law enforcement it was fentanyl, but that's not true. If that statement was only given to attorney Ramos and there is something up with that, attorney Ramos could have become a witness in this case if he was the only one that talked to that witness. That could cause a problem. This interview could cause a problem. The court has been very clear about limiting media in this case. And then the defense, 3 defense attorneys are like, we have to clarify this. It could be an issue with the recanting witness. It could be an issue with the interview. We don't know. But if attorney Ramos has become a witness in this case, we will see that play out. We have multiple affidavits from the prosecutor, Bloodworth, that are sealed. We have an order to show cause motion. We have an objection. We have a response, and they're asking the court to give a ruling on it. And everything that the court seemingly has said about that has been sealed. So at some point, we might get the information. So asterisk this, because I really want to know. The judge is not going to be happy with this TV interview after the defense made their motion for change of venue, had an entire investigation into the change of venue, and used the same firm that was used in the Koberger case. I'm looking for the docket real quick because there was one other thing, and if I don't take this music video off my screen. I'm going to just push play in a very reckless and irresponsible way. But what I will note that's interesting to me is that on the docket, we see, as we're getting into early November, that they recently filed a transcript regarding the change of venue. The change of venue has been denied. The appeal on the change of venue was not taken up. Why is it coming back up now? And is it because of this interview? The defense was very unhappy with the ruling on the change of venue. And now there's this media interview, and now all of a sudden, the change of venue was April 7th, 2025. Why is the transcript of that being filed on the court docket November 7th? Why is it coming up now? And is it because of this interview? What is the defense asking for? Rebecca, I will be at that show. Rebecca said, I'm so excited to see MCR for the first time in Nashville next year. I will be at that show, asterisk. It's at a very tenuous time in the summer, but we're going to move mountains to make it happen. So, what is the defense doing? Why does defense attorney have an attorney appearing on the record? What is this order to show cause about? And what's the fallout from this going to be? Trial is supposed to begin in February. And it took them quite a while to get that trial date because the defense counsel had a federal trial going right before it. They were trying to move that trial date so that it didn't conflict with ski week and it didn't conflict with spring break. And they were trying to wedge it in between those two things to not inconvenience the jurors. There is no next court date on the record for hearings on these motions. And if there are hearings on these, I wonder if they'll be sealed. Something is happening. And I very much want to know what it is. And we might not know till after trial. And I hate that that's the reality. But I think we have two very reasonable possibilities of what this is relating to, just based on the timing and what else is going on in court. It's either that witness or it's the interview. Those are the two things that were going on. Let me know what you think in the chat. Let me know what you think in the comments. A huge thank you to our sponsor, Paradise Paws, who lets me be, irresponsible with my bedtime because I'm playing and irresponsible with my streams when we decide to play music because we love it. And sometimes the songs in our head need to just do all of the things. Law Nerds, I am optimistically traveling tomorrow. Fingers crossed that all of the flight disruptions don't get me. If they do, I'll let you know. I'm going to keep you posted on the adventures at BravoCon. I will keep you posted. I'm sure you'll see me in Up and Adam's content as well, because it always happens when we run around with our phones. And I will let you know. We will be having 2 members-only lives this month, so stay tuned for that. I'll keep you posted in the member spaces. I will keep you updated in the community tab. If anything wild pops off while I travel, which doesn't it always, I will update you in the Law Nerd app. That is where I just, hey, this thing happened. This is what it means. This is when we're going to talk about it. That all gets pushed into the Law Nerd app. And if you want to be in the behind the scenes in the Law Nerd Lounge, lawnerdlounge.com will get you there. Law Nerd app is free on iOS and Android. Law Nerd app at lawnerdapp.com. I will post today. We got to go get the hair done. And I will post about the hair getting done. But now I've got to get going because otherwise I am going to be late and I don't want to screw up Garland's entire day. Law Nerds, you're the best. It's good to see you. Take care of yourselves. Take care of each other. Thank you for being here. Thank you for being a Law Nerd. Something's going down. And I really, really want to know what it is. Hopefully we'll find out. I'll see you guys soon. Bye. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android so I can keep you in the loop. Because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.